All right, hello everybody. Mark Holden, again, in case you forgot. Um, we've got a really good panel here that I'm going to introduce briefly, and I think just a couple of comments before I introduce the panel. Thought the last panel was really interesting, and it kind of reinforced a couple of things for me. One is just the way that law enforcement's thinking about this totally makes sense to me. And it's what I said earlier, just removing these barriers to opportunity that trap people and keep them from fulfilling their potential. And there's many different barriers to opportunity in our country, but the criminal justice system has become one that I think we're going to be able to fix. And doing it in a thoughtful, smart way and not in a top-down approach, a one-size-fits-all approach is the way to go. So I'm excited about that, but want to talk about this panel, which is with the prosecutors. And while the police officers and law enforcement on the front lines are fighting crime, they work in partnership with prosecutors across the country in that mission. More and more county and district attorneys and the heads of prosecuting associations play a significant role in setting policies for comprehensive criminal justice reform that both reduce crime and incarceration and keep communities safer. And one other aspect that a couple times has come up today, just make one comment on, is we've heard a lot about tough on crime and you're soft on crime, and those are just, in my opinion, meaningless political slogans. This state legislator I met in South Carolina, which has done a lot of good reforms, said it's smart on crime and soft on taxpayers. That's what we need to be all about. I think that's right. But we have a panel of prominent prosecutors from across the country here to speak about these issues and why they believe in bringing justice to communities while reducing unnecessary incarceration and how they are working to advance that goal. So first, I'm going to introduce Cyrus Vance. He's the District Attorney of Manhattan and is on the steering committee of law enforcement leaders to reduce crime and incarceration. Hal Harden, is Michael Freeman, is president of the National District Attorneys Association and county attorney of Hennepin County, Minnesota. Next we have David Laban, is the president and CEO of the Association of Prosecuting Attorneys, and Hal Harden is the president of the National Association of Former U.S. Attorneys and former U.S. Attorney of the Middle District, Tennessee. So I'm going to ask each panelist an introductory question, let them weigh in, and if other people want to weigh in on the question, that's fine too, and then hopefully open it up to Q&A. So first, District Attorney Vance, your group, law enforcement leaders, issued a set of recommendations to the President and Attorney General today. Can you tell us more about your recommendations and what you are doing in New York to reduce crime and incarceration?
Thank you so much, and thank you for permitting me to be here today and to be on the steering committee. Ron Serpis, I think, laid out the five very clearly the five principal recommendations to the President from the law enforcement leaders, and I want to thank him for his leadership, and I think the message to the President is very clear. What I would say, focusing then on what we're doing in New York, as Ron was talking about, our job as district attorneys, I believe, is really two questions to everything that you do. Does it make us safer, and is it fair? And if you can answer those two questions for anything that you're pursuing, you're probably going in the right direction. So first and foremost, in line with the recommendations by the steering committee, as I assume all the other prosecutors in the room, we need to focus resources on the most violent offenders who are having the most negative violent impact on our communities. So that is a strategy that I think every district attorney is going to pursue. And in New York, I want to say that I think thanks to several generations of commissioners and partnership with prosecutors, we've done an amazing job, and it continues today. New York's murder rate is down 90% from where it was in the early 1990s, and violent crime is down 85% since the early 1990s. And that's as a result of sustained focus on identifying who are those who are most dramatically impacting our communities. But very much a part of that story, and I followed up the work of the other panel, is New York's focus on making possession of loaded firearms very strictly enforced in New York. And that has had a huge impact on our being able to reduce shootings and homicides in the city of New York, which obviously, number one, in line with our law enforcement leaders, that's what we're focused on. There's legislation pending in both houses now called the Concealed Carry Reciprocity Act in the House and in the Senate, which would make it legal for someone who comes from a state where there is no need for a permit at all to get a gun, and there are 12 states that now have that, to take that same gun and go into New York City and possess it there legally. Come into Times Square, no permit, loaded concealed weapon. That would be legal under the Concealed Carry Reciprocity Act. So I throw that out because I think there are some legislative areas where, particularly big city prosecutors like my jurisdiction, we have 8.7 million people in the city, 3+ million in Manhattan every day. It's a very different thing to possess a concealed gun, I think, in rural West Virginia than it is in Times Square. So I think this is something that we're going to stay on, and it's very consistent with how in New York we're following the lead of the law enforcement leaders. The second thing I'd say is that we are actually very much focused, as I think the police chiefs were, on two issues: race and the perception that our justice system is fair, and policies that live up to that goal. First thing I did when I became district attorney in 2010 was to bring in the Vera Institute of Justice, which is a think tank in New York City, which is very well regarded in criminal justice, to do a racial bias review of the Manhattan DA's office. I wanted to know what was the data in our office with regard to whether there were statistically significant differences between Asians, African Americans, Latinos, and whites in the outcome of certain cases: plea bargaining, charging, sentencing recommendations, and the like. It took 3 years for Vera to do the study, but it was very informative to me, and I was, I think, as a leader of a very large criminal justice agency in New York, then able to communicate to the public transparently, this is what we found about how we're dealing with race in our office. But more significantly, what it's done in furtherance of the pursuit of the law enforcement leaders is it's led me to completely rethink who we should bringing into the criminal justice system in the first place. And since the Vera study, I have focused with my team on radically reducing the number of low-level offenses and offenders that we prosecute by crime. I'm not suggesting, like broken windows, that there shouldn't be a consequence for misconduct, but you can drive 75 miles an hour down the West Side Highway in New York City and get a speeding ticket. But if you jump over a turnstile to get into a subway, you're going to get cuffed and go to jail. And so the consequence is not proportionate to the offense. In the last 4 years or 5 years, we've gone from about 90,000 misdemeanor and violation arrests. Those are our lowest cases that we used to process from the police. They would come in by arrest or by desk appearance ticket, and we would bring those people into the system and process them criminally. That number's reduced now to about 60, and will go down to 50 by the end of this year when we work toward not prosecuting those people who are jumping turnstiles unless there's a reason for it. They have a gun or a warrant. And what we've found is that this is not disregarding broken windows policing. What it's proven is that you can, in fact, have consequences for these low-level offenses, which are diverted at the station house, and there is community service, and there's perhaps mental counseling. On the range of these tens of thousands of offenders, crime still goes down. It has gone down. So you can have effective response to criminal acts at the low level, provide support and intervention for those individuals who commit those acts, but not have them processed criminally, and the city can be safer. So you, like the law enforcement leaders recommend, we want to be tough on violent crime, but we want to be smart and we want to be fair on the other kinds of criminal misconduct so that they are treated rationally, and that restores faith between our communities. Our entire office now has gone through implicit bias training. First, all the lawyers, all 600 of us, and then all the staff, all the professional but non-legal staff, another 700. It's about, I think partly it's about telling the public that we get it, that race is really an issue in our communities, and we are finding a way, imperfectly, to acknowledge there's a reason why 90% of the people in our courtroom are Black or Latino. I mean, that's a fact, and we need to understand why is that, what can we do to change that picture, and as a major organization, to be transparent about how we deal with it. So those are some of the main things we're doing. I must say mental health, all the conversation about mental health, hugely important. We all need to do better. We committed about $40 million of our forfeiture funds to the mayor to help him train police officers and create drop-off shelters so there was an alternative to arrest. But at the end of the day, what I see in terms of being smart on crime, taking a look at these smart strategies is we need to be more collaborative. We need to be more accountable. We need to be more honest about where we are not doing the job that we do or where the public last conference, and we need to have data to be able to communicate to the public about how we're doing and how we're not doing. And I just want to say we've got some great New York law enforcement leaders in the audience here. Jeremy Travis, I know Zach Carter is here, and David Soar is our county DA in Albany. And they are phenomenal partners, and I think all of us in New York are walking the same direction, each in our respective agencies and offices.
Thank you. One just quick follow-up when you were talking about what you've been doing in your office. I do a lot of work with the Barred Prison Initiative.
Yeah.
Coke does as
Yeah.
well.
Yeah.
And could you speak just on that and what you think about that program and why it's so important?
Well, we are blessed in Manhattan, first by having smart prosecutors, but secondly by being a financial capital in the world. So all major criminals do something in Manhattan that enables us to investigate them. And mostly what it often is, it's moving money. It's transactions that may be in violation of a federal or state statute. The money typically goes from one currency to another, and those transactions are cleared in New York City. The bottom line is, in the last 9 years, we have prosecuted 12 banks and received 10 banks and received $12 billion in forfeiture. 6 went to the federal government, 6 went to New York State. A portion of that went to our office, which was $800 million. And what we've done with that money is try to make transformative investments in criminal justice. One of those investments, one of the smaller ones though, was to fund college prison education. Jeremy Travis, when he was at John Jay, was very much involved in this. We all know one thing: the most effective reduction in recidivism strategy is to get a college education for someone who's incarcerated. That individual, when they get out of jail, is the least likely person to recidivate. So it's really not that hard to know where to invest your monies if you want to help folks who are in jail. They've done their time. Now they need to get out. They need to get on with their life. We need to support them. And if we're going to send them to jail, which we're going to do, as some commissioners said before, we need a game plan while they're in jail to prepare them from the outside world so that when they get on the outside world, they're not back in our courtroom. And it's a less expensive, more thoughtful, better way to go to invest in their success.
Michael Freeman, I want to talk to you about your role in the National District Attorneys Association, which came up very strong in favor of the criminal justice reform issues at the federal level. Just talk about your group and what you're doing and why you're doing it.
Well, thank you, and I'm glad to be here as I was with the other leaders of the law enforcement group in New York 2 years ago. Ron, I was there with you and lots of other folks, and this organization gives us a chance to think and to challenge each other, and I'm pleased to be a part of it. And Cy, like you all with New Yorkers, we Minnesotans travel in packs. You heard Sheriff Stanek say nice things. Rich, don't forget that when I'm standing for election next year. I have my brother John Choi, who is the county attorney in Ramsey County, which is St. Paul. Our Minneapolis City Attorney, Susan Siegel, is here. We're glad to have you, Susan, as well. And we even have a professor, Mark Osler, a former AUSA, and now he's checking up to make sure I haven't forgotten my progressive tendencies. I want to talk about something just a little different. I want to talk about a big picture issue that we face in Minnesota and people face elsewhere. That is the lack of support and trust by the people we serve. And it's most manifested in officer-involved shooting cases that end up in the death of a civilian. I've got 2. John Choi had 1. And it's very clear that they are terribly challenging to our system. If we're going to make reforms, if people are going to trust us, we need to work very hard on what we have to do. Now, I'm not going to talk about the police. I'm not a police chief. I'm not trained that way. But I am a prosecutor. And I want to talk about what we can do to enhance our accessibility and our transparency. And there are 3 issues I want to talk about. First is the investigation. Now, In the little jurisdictions, they simply don't have the capacity, and they send the investigation to the sheriff or the State Bureau of Criminal Apprehension, as they should. In the largest jurisdictions, for example, NYPD has a separate entity, and they've cultivated that, and I think they do a good job. It's the middle-sized folks like Minneapolis, like Indianapolis, and a lot of other places. Who does that? And of course, Minneapolis PD, like Indianapolis PD and lots of other places, said, we can do it, we're big enough. In my view, you may be able to do it. You can't do it with the faith and the trust of the people you're trying to represent. And so I've urged very hard in Minneapolis to send it out. Our cases are sent to the Minnesota Bureau of Criminal Apprehension, and there's enough additional space that we think we need to. Some of the cases go to Sheriff Stanek and his folks, and it's kind of a local decision where to go, but do not try to do an investigation of a police officer shooting case resulting in death of a civilian internally, with some rare exceptions. Number two is the whole question about the grand jury. In Minnesota, each county attorney gets to decide when and where they use a grand jury, and for over 40 years we did that, use grand juries on police officer shooting cases. But after Michael Brown in Ferguson, I began to look at this, and I began to talk to people in our community, and they frankly really didn't trust the process, and they didn't think it was right, and they didn't like the grand jury. If you think about it, the grand jury was created in the first place to give some space away from the Sheriff of Nottingham, who was unduly charging people back in England. Okay? But the problem is the grand jury is secret. No one knows who's on it. Its proceedings are secret. And we prosecutors cannot reveal, at least in Minnesota, what evidence was presented. So you got this anonymous group meeting in secret, getting information that we can't tell the world what they got. And after meeting with groups small and large, of various colors, various denominations, various economic backgrounds, I just felt that modern concepts of openness and accessibility and transparency just didn't allow me to use a grand jury. So in our cases, I make the call, not alone, with some brilliant and experienced prosecutors, but I make the call. If you don't charge the case, then what I did in the Jamar Clark case, tragic death of a young black man at the hands of two white police officers, who the evidence showed had his hand on the officer's gun. And I'm sorry, in this world, you put your hand on an officer's gun and try to steal it away, you're probably going to get killed. And that's what happened to Jamar Clark, tragically. But what we did then is we had a press conference. I explained what the law is, what some of the changes I thought ought to be made, and I took the people through all of the facts, including showing for the first time the video. Now, some folks didn't like that decision. That's part of a prosecutor's job. But they knew why and how I did it. And the next thing I did, which has not been done elsewhere in the country to this extent, all the police reports, all the forensics, the autopsy, all the video went on my website that day. And in the first week, we got 165,000 hits of the police reports and nearly 800,000 hits on the videos. Everybody wants to see the videos. So everybody could understand what were the facts that I made the decision on. Now, doesn't mean everybody liked what I did, but it was a step towards transparency and accountability. Like I said, next year in November, I'm up for re-election again. Well, they didn't like the decision or didn't like how I did it. That's what democracy's about, and I'll take that challenge. But they also had a chance to evaluate the facts for themselves. So what I'm urging in a smaller forum for prosecutors to try, particularly in those most difficult cases, to be as accountable and as transparent as you can. And I'm urging everyone, including law enforcement, to think about how you used to do things, and is that a way that's really transparent, and does that build trust? And I think when we do that, we do our job better. Thank you.
Mr. Laban, I presume, yeah. Would you please discuss why you believe in what the law enforcement leaders' recommendations that were given to the administration and Congress, why you believe in them? And then you and I were speaking previously about recidivism and ways to reduce recidivism. And how do these reforms help address that issue as well.
Excellent. Thanks, Mark. And I want to start out by also thanking the Brennan Center. And looking around the room, I think there's more than a few people who know who I am, so I don't think I could go by another name or some other identity. So I think I am properly identified. My name is David Laban. I'm the president and CEO of the Association of Prosecuting Attorneys. APA is a national association located here in Washington, D.C., serving prosecutors as well as the law enforcement and community partners. We represent many of the largest and finest offices in the country. One of my board members is right next to me, is the Manhattan District Attorney Cyrus Vance Jr. Thank you for giving me a few moments to speak with you, and it's been an honor to be involved in the organization of this. I really think that for Brennan Center to involve, especially the prosecutor piece, we're working the association whether we're going to have a prosecutor hat or some epaulets. We've got to have something because on the police side, you guys have outstanding uniforms and stars, and it looks great, and we are insanely jealous of that. But the key of having the prosecutor in there is that justice reform. This is really, really tough, and for us to be in it together, it magnifies each of our voice. And so I think that's really one of the key things. We've just heard from both DA Vance and County Attorney Freeman. They've told you some very practical things. What are they doing in their office? What are they doing in their state? Love the transparency and looking at the officer involved. We actually, both organizations together, we had a project and we ended up on the APA side with at least some policies and responsible transparency being one of the really, really key links. But I'm going to let's do kind of the 30,000-foot view, and then especially let's address the 5 points that have been presented to us. Looking at APA's mission, our mission is to support and enhance the effectiveness of prosecutors in their efforts to create safer communities, ensure justice, and uphold public safety. Our policies demonstrate support for evidence-based sentencing and prosecutorial practices that prevent crime, ensure equal justice, and ultimately make communities safer. Ron, did I cover all those points properly? See, he's now a professor, so he's really helping me out. What do we look like, and what have we tried with our key principles? So criminal sentences should be proportionate to the seriousness of the crime committed, and incarceration should be limited to the cases where it's used to improve public safety. Everything should be through the lens of what's the public safety benefit of doing something. Second, diversion programs are only sustainable if community resources exist to treat, rehabilitate, and address the needs of individuals who commit those offenses. Third, optimal selection of individuals into diversion requires leveraging a data-driven, specific approach in using your science to ensure maximum reductions in the rate of recidivism. And finally, regardless of whether an individual is ultimately incarcerated or diverted, the top priority of sentencing should be rehabilitation and reintegration, and individuals should face minimum collateral consequences upon reentering society. And I'm going to divert for just a moment because that's what Mark and I were chatting about. What is the secret as it goes to recidivism and reentry? It's a job. And I love DA's Vance comment saying, why wouldn't we educate so if you're getting out, that you're out, you've got a degree now, why do you want to go back and do what it is or what you have been doing, which got you involved in the criminal problems? And then for the discussion of this is really soft on crime or this is easy, that we're hug-a-thugs. I'm up here, and we were just looking at some of the numbers. I'm a guy who tried over 100 cases to jury. I was assigned to a police department to work on the community relations, all the things discussed here. And what do you do about the gang violence? And going on the research base, reducing that gang violence by 50%. But I prosecuted everything from petty misdemeanors to special circumstance murders. And many of the folks that I prosecuted are still in prison today, even though I've been doing other things for a while, and that's where they belong. And so to say that I'm a hug-a-thug, no, I've sent plenty of folks to prison for life and believed in what I did and would do it again if presented those cases and facts and those victims. But anyway, by utilizing the community-based problem-solving framework, key partners can work collaborative in creating and implementing and creating safer communities. Now let's go to the exhibit. Same thing being a trial lawyer. You asked me about these 5 points. How does it weave with what we're trying to do? First, it's necessary to prioritize resources to combat violent crime. We heard it from the chiefs on behalf of prosecutors who want to say the same thing. In an overburdened system, low-level offenses must be diverted away from the criminal justice system so that resources can be concentrated on the violent criminals. By focusing our priorities and resources on the most dangerous threats to our community, we can make our nation safer for all. Second,
We support reducing unnecessary incarceration. As prosecutors, we recognize the importance of treatment, alternative programs, and seek to reduce recidivism by safely diverting individuals from arrest and jail booking into community-based programs. Alternatives should be available for anybody who does not pose a public safety risk. Anybody. Let's look at it. I love what Chief Acevedo said about, right away. Why are we booking them? Why are we processing them? Sheriff Stanek, to think that somebody's sitting in that jail that's never going to be 36 hours on a PC hold, it's never going to be a case in Mike's office. We got to figure that out, and we got to do it quickly. And then it's especially true for those who suffer from substance abuse, mental health issues, dual diagnosis, who often are entangled in the criminal justice system. Community-based treatment programs and other supports are the most appropriate way for addressing their needs. We can have community supervision when it's necessary, driven by the particular circumstances. And preferably, justice, health, and community resources should be allocated to the intensive and comprehensive services that demonstrate the greatest capacity to reduce recidivism, protect public order and safety, promote public health, by also mitigating the need for costly criminal justice intervention. To ensure success, prosecutor's office should operate collaboratively with all other criminal justice and community partners. Through joining forces with other community agencies, there can be better integration of services as well as resources. Consequently, all members of the community will have a greater stake in the outcome and will be able to provide meaningful contribution to the overall goal of improved public safety. Closing up, investments in reentry are critical to preserve and expand recidivism reduction. The reentry process should begin at intake. I'm going to say that again. Reentry should begin at entry. It ought not be a situation that throughout the time of incarceration, nothing was done to address any of the needs, the criminogenic needs that led that person into the system in the first place. And services should be front-loaded upon release. Expanded reentry services will help decrease the overall rate of recidivism. In turn, this reduces crime, reduces the number of incarcerated individuals, the number of crime victims. We haven't heard a lot about, but all these crimes behind it, especially crimes against persons. You got families out there. And then someone talked about you go also save taxpayer dollars. In closing, thank you for involving the prosecutorial profession in your efforts to both reduce incarceration and provide for safer communities. We stand with you and look forward to continued collaboration to make our nation safer.
Thank you. Mr. Harden, I want to talk to you about the federal system. We're obviously talking about reforms today at the federal level, but could you give us your read on what the biggest problems are in our federal system and what's the best way to try to correct them?
Well, thank you. I'm honored to be here today. It's impressive that at last some people are concerned about these issues and are getting together to discuss them. As introduced to you, I was introduced to you, excuse me, as the president of the National Association of Former United States Attorneys. We are a bipartisan group made up of a lot of Republicans and a lot of Democrats, and we are devoted to preserving the integrity of the litigating authority, to defend the independence of the U.S. Attorney's Office. And because we are bipartisan, we very seldom take a public position on most issues. Therefore, the opinions that I express here today will probably be my own and not necessarily those of the membership. But one other thing I wanted to correct. I am the president-elect, and the board meets Friday, and the membership to vote. And after this presentation and tonight's party, I may not be the president. So with that in mind, when I first heard about this, I attempted to make a list of the problems that are in the federal system. We have some problems, such as diversion, that you don't have, and I'll address that a little bit more in a minute. It seems that every time there's a problem in society, there's always a rush to somebody that's saying, we need to pass a law to take care of this. As a result of that, we've got over 5,000 statutes and heaven knows how many regulations, nobody's ever counted them, that make various offenses criminal. It's said that every American probably commits 3 felonies a day, from tearing off a mattress sticker to imitating Smokey the Bear. It's a lot of silly offenses out there. The greatest problem, in my opinion, that we are facing now, federally and locally, is the opioid crisis. It's not only a criminal issue; it's a health crisis. We have numerous hospitals in Tennessee where we have wings that just have little addicted children in the wings, and just imagine what's the future for these kids and their kids, and for us as a society, and how much all of this is going to cost us. We're going to have to spend a fortune to overcome this horrible, horrible problem. So what are the solutions on it? Well, drug incarceration. I mean, there's been some studies that show no correlation between drug imprisonment and the rates of drug usage, arrest, or overdose. One thing that we have done in Nashville on a local basis is an old associate of mine, he's now a judge, has started, and Chief Serpaz knows him and knows the court well. He started a drug court, and is the nation's first residential drug court, where he gives them a chance to either go to jail or you come in here for 18 months and be rehabilitated. The recidivism rate in his court is like 30%. He figures that we are saving with each taxpayer, with each defendant, some $37,000, and that's not including the long-range benefits of getting somebody off the street and rehabilitated. But we still have problems. I'll give you one example from last week. There was a young, handsome African-American man, about 20 years old, and he's passing the drug court with flying colors. He's bright, he's funny, he's energetic, he's a leader. He's going to graduate, but he has no place to go. When he gets out on the street, that's it. And the streets are full of danger, which is one of the reasons that this is such a great problem and there's so many components to it. Affordable housing has to be a part of the solution. Let me just read to you a little thing I pulled off the internet from my TV station down in Nashville a couple of days ago, and quote to you some doctors in Nashville talking about this problem. Emergency room doctors say the opioid crisis isn't getting any better, it's getting worse, especially in Tennessee. Emergency rooms are supposed to be prepared for emergencies, but some doctors say they are seeing more and more people coming in faking pain just to get their hands on narcotic. Specifically at St. Thomas Hospital, it said we don't have the ability to treat somebody for opioid withdrawal, said the emergency room doctor. He says, I have grandmothers, great-grandmothers, soccer players, CEOs, everybody, lawyers, doctors, and whomever, coming in wanting to get treatment or wanting to get drugs. They say they're coming in because they're all addicted to narcotics and they're looking for help. We're seeing more and more patients recognize their problem, wanting to get help, and are there for very limited resources, but there are very few limited resources for them, especially for the uninsured. Doctors also say some coming in faking pain just to see how many narcotics they can get. It's a problem in all of our hospitals. It is a true emergency. In one 8-hour shift at Vanderbilt emergency room, a doctor sees 12 to 15 people either looking to get their hands on whatever narcotic he'll prescribe them or looking for help in getting them. Some of these people will even inflict themselves with knife wounds or whatever in order to get these pills. Addiction and the abuse of these drugs can happen to anyone at any time. But the TBI, our Tennessee Bureau of Investigation, says their biggest battle is phenethol, a powerful synthetic drug similar to morphine, which is an elephant tranquilizer. And what these people are doing now is you're getting more and more of these prescription pills off of the street. They're making these artificial pills. Some of them have a high potency and some of them have just a little bit, and you get. If you take one that just has a little bit of drugs in it, you think, well, the next time I'm going to take 2 or 3, and it kills you. It's that serious. It's Russian roulette with these kids out here taking these pills, and it attacks everybody. We have a wonderful mayor in our town, who some say will maybe be the president of the United States someday. Just last month, her 20-year-old son overdosed. Her only son. So it strikes all strata in society. So what else is wrong, and what can we do to correct some of these problems? First of all, let me tell you a few more problems that we have and that you guys don't have. Number one is pretrial diversion. We hardly ever have that in the federal system, and when we have it, it is totally bureaucratic. When I started pretrial diversion years and years ago, the pretrial diversion was I'd call the little bank teller in who had stolen $1,000, who's 19 years old, and wasn't worthy of federal prosecution, and you just say, "Now, young lady, I'm going to put that file on my desk right over here, and I'm going to leave it right here, and I'm going to see what you do in the next 6 months." And depending on what you do in the next 6 months is going to be the way I'm going to make my decision. It didn't go anywhere else. I was trying to get pretrial diversion recently in a district, and I had to go through 4 assistant United States attorneys to get a decision, plus the probation officer. Going to get it on a very simple, minor thing that shouldn't have taken more than 20 minutes. And it wouldn't have taken you any more than 20 minutes in your system, I know. Expungement, where a record is expunged. I mean, if you have a record today, it's like going around with the scarlet A on your forehead. You're banned for life in many ways. We hardly have expungement in the federal system, even when you're acquitted. I represented a congressman once, and I said, after we acquit you, you're going to promise me you're going to pass this law. He said, hell yes, I'm going to pass this law. This is the damnedest thing I ever heard of. You can't get this thing wiped off. He never did a thing. It remains, it was, and still is a serious problem. I got another client who's 90 years old. He, 30 years ago, did some white-collar crime, got probation, and he said, I'm a millionaire. He said, I would give $1 million if I could go hunting like my grandfather did with his grandkids. Money means nothing. Just to be able to get out and go with my boys would be the greatest thing in my life, and I would easily pay $1 million if I could do that. We need this expungement law, and after a certain length of time has passed, I believe that old felonies should be expunged. Often in the state system, you guys have better laws on this and deal with it much more effectively than we do. I think there has to be an early release from the penitentiary of our dying prisoners and the ones that are really ill. It's amazing to go to some of these federal prison camps and see these old men and women walking around or in wheelchairs, and the Bureau of Prisons just cannot take care of them. They don't have the money. They're understaffed. There is a move afoot to let these people be released early, and it should happen. There's no reason why we, the taxpayers, have to pay for these people when they're 70 and 80 years old and their family's willing to take care of them. We need, as I said earlier, jobs for our youth. Our mayor in Nashville has finagled something like $50 million from businesses there to give these kids from the ghetto some opportunity to work, to be interns in the summer, and to get them off the street, give them a sense of pride, and show them that there's another way instead of becoming a drug dealer or stealing from the local store. We need to have more police and community involvement. There needs to be more meetings, in my opinion, between the police officers and the community. We had that at one time, it seems to me like, Chief Surpaz. where there was more talk. Well, policemen were buddies. They very often would let you go home if you might just have had one beer. They had more discretion. We have laws on our books now where if you call 911, even by accident or just because you were temporarily mad, somebody's going to be arrested, one or the other. So somebody's going to jail, and there's going to be a cooling off period. It's not any fun. The officer has no discretion whatsoever. That should be changed. There should be a revision of the criminal code. We've talked about this for years and years and years, and I doubt it'll ever happen. But, and I think also that the role of probation officers should be revisited. When I first started practicing law, the probation officers we sensed and the defendants felt were there to really help them and to rehabilitate them. Now, more and more, the feeling is the probation officer is just here to be an arm of the U.S. attorney or an arm of the court. But these are just some of the problems we have, and there'll be more, but it's groups like you that can and are making a difference, and I personally and professionally thank you.
Hey, before I open up to questions, that was a great presentation of all the flaws in the system. The one thing I'd like anyone here to comment on that I think was missing, and it's not a criminal justice reform issue per se because it's already in the Bill of Rights, the Sixth Amendment right to counsel. And with some of the estimates I've seen are 80% of the people who get caught up in the system need a court-appointed lawyer, so they need an indigent defense counsel. And there are some states that works well, federal system works well sometimes, but by and large, it seems that their public defenders and court-appointed lawyers are out-resourced when it's compared to you all, and prosecutors have more resources. I mean, I think the deck is stacked against people who need a court-appointed lawyer and an indigent defense lawyer. How do we get back to what was the issue? I mean, it's a natural right in the Sixth Amendment, in our Constitution, that if you're accused of a crime, you have the right to an attorney, and it should be someone who's skilled in that area. Just want your thoughts on it, where it works and doesn't work, and what you've seen.
I can start. I was a defense lawyer for 20 years before I ran for district attorney, and I handled a lot of court-appointed work. So I have a understanding of the restriction on resources that comes to either a court-appointed lawyer or to a legal aid public defense agency. First, I think the legislatures have to step up, and they need to provide adequate funding, and that has to be done after a study and a needs analysis. We ought to be having caps on the number of cases that public defenders carry, and I think we now have this in New York, and I think that cap should be a reasonable amount. If a public defender has 500 cases, that's not fair. And we're trying to reduce our caseloads in our office, but the public defenders also have that need. So I think that that those of us in the bar, frankly, those of us who are lawyers in the criminal justice system need to step up, and we need to say we need to support both sides of this equation. And I think anyone who's been a prosecutor will say if there's a good defense lawyer on the other side of the case, things go much better as opposed to an inexperienced defense lawyer or a lazy defense lawyer. So we're all responsible for upping the game and upping the practice, and not just in our own offices, but also in supporting our colleagues who do criminal defense work, which is really, really, really important work.
I just say that the National District Attorneys Association, which I'm proud to be its president, has advocated for joint training between prosecutors and public defenders. A joint facility, training together wherever possible, and obviously there's some strategy and strategic things which we need to do separately. The United States Congress is shocked that we can get together, and has moved very slowly, unfortunately. But I think we prosecutors need to support public defenders. Si's absolutely right. You got to have a good prosecutor, a good public defender, and hopefully a good judge. And then you can move that, and I'm going to leave the editorial comment on that one alone. But I think one of the places we can start is trying to do some joint training and things, and we are advocating that at NDAA.
I guess we'll just keep going right down the line here. I'm going to join in both Si's and Mike's comments and kind of push it to one more level. And it is the system overall, the local criminal justice system in the courts, is in crisis. There are not, so I'll start on the prosecutor side. I don't know a single office that says, I've got too many lawyers, we don't have enough cases, folks are wandering around the office trying to find something to do. Doesn't happen. The same thing over our colleagues on the defense side. And then, can you get a place, and I guess we'll pick on Minneapolis one more time, can we get to a court? And we'll move away from Minneapolis. Houston. I was shocked when I heard how many criminal courts there are for Houston, fourth largest city in the country. They have like 80 or 90 criminal parts for that entire city, for that entire caseload. You wonder why things aren't moving? There's not enough resources there. So as we talked about with the use of the resources that we do have, that's why we've got to get rid of the junk. We've got to get rid of the low-level cases. We've got to get rid of the cases that never, ever belonged in the system. And then at the same time, we've got to slow it down, and we've got to do it right. If you're going to start picking and getting folks into program, if we're going to work towards, I think the keys are health, housing, education, and employment. If we're going to get folks out of that cycle, familiar faces, revolving door, whatever phrase anybody wants to use, they need that. How are we going to get it? If there's going to be court supervision, there's got to be proper defense, there's got to be proper prosecution, and there's actually got to be a place that both of us can practice in front of. So the entire system, and that's why we need all of your voices, and we need to be in it together. But we can do better, but we can only do that if we have the resources.
In our part of the country, we have one of the best public defenders that you could possibly have, well-staffed. And when he has a conflict, he delegates the cases out to what he calls a panel of lawyers, who are lawyers that he has picked as being competent, and they pay him decent rates. Contrast that with the state lawyers who are being asked to defend cases. Oftentimes, there's no lawyer in these small counties that really has any criminal experience, and they pay them like, I don't know, I think it's $40 an hour, but it's going up. And with a cap on it, there's just no way that you can handle a case like that. And some of the lawyers I've been reading on blogs here are going on a strike. Ethically, I just can't handle any more cases, and it's just unfair to the client, and it's unfair to me. And if I'm held in contempt of court, I'm in contempt of court, but I'm not handling any more cases.
Open up to questions. First, I'm supposed to prioritize with the press, but anyone, media? Sorry.
I'm Steph Kite from Axios. And a couple weeks ago, some Republican senators brought up a bill advocating for mens rea reform, and I was wondering what your positions were on that. Thank you.
You want my position? Yeah, I think it's great, and it's pretty much a fundamental of any criminal justice system that's just, that you have to have a criminal intent before you can be charged with a crime. And I'll let the professionals talk about this, it's usually not a very high bar to meet. I think that it's important to have that in there if we want to get enough conservatives on the bill to get the sentencing part passed as well. There's going to be a give and a take. And I think one of the important factors, another important fact here is that the bill that Senator Hatch entered in the Senate, it's supported by the National Association of Criminal Defense Lawyers, which is a great organization that we work with, and also by the federal defenders. And so those who are indigent defense lawyers, public defenders, they support it. So I think it shows that there's not a real big issue divide here between the left and the right. This is a justice issue for a just system to have those types of standards. That's my point of view, but interested in yours.
Well, I will confess I don't know exactly what crimes they're being focused on. In our practice, proving criminal intent is 95% of what we do, and we accept that burden, proudly, and we have a burden beyond a reasonable doubt. So intent is nothing new to us, at least in the state system, and there are going to be certain crimes which for which the standard of conduct is recklessness or negligence. But I also am not offended by a homicide case, for example, having various levels of intent. Intentional murder, reckless murder, negligent murder. I think that makes sense because that often fits with the fact pattern that you're presented with. So it really depends on the crime. And I know in the federal law there are some crimes, for example, environmental crimes or crimes involving manufacture of drugs, where if you dump 1,000 gallons of toxic mixture into a lake, you're liable, period, whether or not you have criminal intent. And if you sell tainted drugs and someone dies, you may be liable, tainted. I think that on those crimes, we really need to look at the facts of. I'm not opposed to those crimes because they're created that way. Because the consequence of putting pills with cyanide or putting something out that kills 1,000 people has to have a consequence.
Yeah, but some of these, and unfortunately, I'm familiar with environmental criminal allegations and the work I've done. Most of those statutes have a criminal standard in there already. Yeah. So it's things like, Al Unser or Bobby Unser, one of them, who drove his snowmobile onto federal lands and didn't have a permit and was charged with a felony, then pled guilty to a misdemeanor. I mean, it's things like that. And I think it's a lot of the drug crimes, as you mentioned, war on drugs.
But let me suggest it's not only that, this is not an abstract issue. Vern Gagne was a famous professional wrestler from Minnesota, and Vern developed dementia, and he was in the nursing home where my father was. Well, Vern and a gentleman kind of had a little altercation. This man was a concert pianist at 90, or violinist at 90, and Vern just got upset and gave him a body slam, broke the guy's hip. He went to the hospital to get it set. 2 weeks later, he developed infections and died. And it landed on my lap. Can a guy like Vern Gagne have sufficient mens rea for me to charge? And after a lot of soul searching, I said no, because he simply didn't have the capacity to do it. Now, the family in this case was quite understanding. In a separate case by someone not as popular or well-known as Vern Gagne, the family had a fit. They wanted me to charge that. And I can't help it but add a little thing here for folks, too. The question about prosecutors reviewing cases and declining them is one of the toughest things we do. Nobody knows but that prosecutor and people in his office all the facts of the case, and no one can know. And so with rare exceptions, I think what I'm asking for is support for me when I make a tough one on Vern Gagne and some of my sisters and brothers making tough cases elsewhere, because it is the toughest thing we do. And I know very few cases in which I've ever disagreed with a sister or brother prosecutor who have gone through the agony of looking at the case. I just want to say that.
Well, as one who told his office not to prosecute a man carrying a pistol in the airport, to give it over to Metro, named Donald Henley, I understand that.
Yeah, I think to touch this, because we've been involved in criminal justice reform, and another thing that was brought up here was asset forfeiture. So I think when you look at the community and representing sort of the moderate prosecutors, you have the conservatives and the liberals and the wraparound on asset forfeiture and also this mens rea issue, saying that together. And what's the concerns with mens rea? It really wasn't addressed here. What you're doing in the legislation is, rather than fixing the warts, and that would be the same with the asset forfeiture, where are the problems and how can we stop those bad results? Because on behalf of the justice system, we want it to work. But instead, when you say, well, if there's no mens rea, it's going to be specific intent. What you're going to do now, and it's going to end up causing lots of pain to the U.S. Attorney's Office, because people are constantly worried about white-collar crime. Now with white-collar crime, the only person you're going to be able to prosecute is the lowest level. And you think about, how many people say in 2008 with the meltdown, who got prosecuted,
right? That we did, as prosecutors, we didn't do our job. By making it specific intent, you're never going to be able to go up the chain. You're done. If it's not the person who touched it, then there's not going to be any crime at all. So we're all into, can we fix the code? And we need the U.S. Attorney side, because as has been talked about, we're on the state side. On the U.S. Attorney side, we need those experts. We need the federal defenders to come in together and say, let's talk about where are the problems within the code. Let's fix those. Let's not have a bill that just says, in the 5,000 federal offenses, if for some reason the legislature didn't give it a level, we're going to substitute one right now.
I think the Hatch bill doesn't do that. It's prospective, forward-looking. If there's not a criminal intent standard in a new law passed by Congress, any criminal statute, that will supply that default standard in that bill would apply. So it's not backward-looking.
That's at least a step forward. But even then, why don't we just urge the Congress to pass good laws and to say if you're going to create a new crime, put the intent in there of what we all have to prove.
Yeah, I'm for that. That's great.
There we go.
Yes.
Hi, my name is Becky Vandercook. I'm from CBS News. Just to follow up on Mr. Freeman's point about how difficult it is to make that decision to drop certain cases, this is a question for Mr. Vance. Do you have any further comment on your decision to drop the 2015 case against Harvey Weinstein?
Do that off. I'm sorry.
Yeah.
Can we,
I'd be happy to talk with you outside. We're just trying to keep the questions on topic.
Great, understood.
thanks. Someone, if you got a question, then yeah. Go ahead.
Hi, Cami Chavis. I am a former prosecutor, former AUSA from here in the district, so I was very happy this morning to hear that there are no more jump outs in Washington, D.C., the chief said. But we've talked a lot about the opioid epidemic and the current problem that is causing. As a prosecutor here in the district, I mean, there was a crack epidemic happening, and the conversation is very different. A lot of people would say that's because of the face of the opioid epidemic and the crack epidemic being traditionally focused on people of color. And so we've learned a lot in the past 20, 30 years. We've learned a lot about mistakes that were made. And as prosecutors, do you see any measures? How can we prevent some of the racial disparities that happened with the crack epidemic? How can we prevent that from happening with the opioid epidemic? My concern is that a lot of the diversion that we see that's happening and the focus on mental health and public health is still going to be reserved for not people of color.
Let me take a whack at that. Many of our offices have undergone the kind of examination that Cy Vance has done, reviewing the cases that we have, and do we charge differently because of the race of the individual? Do we do diversion differently? Well, we had extensive scrutiny of our juvenile charging because we do all the juvenile cases in Minnesota. And I'm pleased to report that we presented similar identical cases and changed the names to obviously particular name that fit with a racial group. We didn't find a discriminatory result depending on what appeared to be the race of the individual in terms of the charge. We did in diversion. And we looked at it and tried to figure out why. Why were white kids completing diversion better than black kids? Well, we dug a little deeper and we found out because the black kids, because they're moving more often and because of the difficulty in finding, we were sending them a letter, and that's all. And if they didn't do that, then we put them on a warrant list and we'd haul them in, et cetera, et cetera. Well, you know something? Our dentist calls us, don't they? And tells us, you've got an appointment in 3 days. Couldn't we do that for kids? So we called them, or we went out to their house, and guess what? In the last 6 months, our diversion rate between white and black kids successfully doing is almost exactly the same. So we need to look at this stuff, and Cy and his office has been much more extensive. You know, it's expensive and it's hard to do, and frankly, it's scary for some folks. They don't know what like. But at least we found in our county, which is by far the largest in Minnesota, that between black and white kids, we didn't. I think that's what we have to be mindful of that. And frankly, we have to have the guts, and it's not always easy, particularly the year before election, to have that kind of scrutiny done.
In Manhattan, we had about New York City, we had about 1.3 million outstanding warrants. And those ranged from mostly very minor warrants for not showing up when a cop gave you a ticket for some civil offense. And most of the folks who were affected are men and women of color in that 1.3 million category. So what I want to say in response is sometimes we have to look at the reality of what we have and go back and just fix it, even though it's a big lift. And what I spent about 3 weeks ago, I appeared in court and moved to dismiss 240,000 cases. And they were cases that were older than 10 years old, where there was a warrant appearing on an underlying very minor infraction. On my weekends, we would hold individual events in churches where we would have people come in and be able to clear those warrants out individually. And what I learned was most of the folks who had those old warrants when they failed to show up for some minor infraction was like not having your dog on a leash, having a bottle of beer outside of a bag. And when those folks came in, some of them after 25 years with warrants, and they've been living in the margins and scared to get jobs, scared to report to the police, scared to get employed. It really is something that I didn't fully appreciate. Sometimes we have a system. We have a system that was very aggressive in ticketing because we thought it was the right thing to do back in the 1980s. But that itself created its own problem. Maybe it was because the folks moved and the letter didn't get to their address. Maybe they got scared, or maybe they couldn't miss a day of work. But the point is, there are things that we can do looking backwards on cases that are not going to threaten our public safety. None of these people in the last 10 years have been in trouble. And we can make a statement, which is, sometimes the justice system just has to realize that we kind of screwed it up here, and we need to give folks an opportunity to have a new start, a fresh start, and that's one approach.
And I think so first, thank you for your service, because being AUSA for the rest of the crowd, that is really the local prosecutor. So yes, you wear the federal hat, but you're getting your hands dirty with the street crime. I think lots was learned from the crack and from the other drug treatment and such. The other thing I want to say with opioids and opiates, if you look at the heat map, this is an East Coast problem. A lot of our members on the West Coast are, why are you talking about that? We still have methamphetamine. We've got other troubles. So there we go. See, so it's all that particular region. Is ask them what their drug is. But let's get right back on that point. These are being discovered generally by overdose. And so it's a very good example of folks not thinking in an overdose situation, let's arrest them, right? Let's get that case filed. No, let's save that life. Once you get done saving that life, what are you going to do to try to make them whole? And so they don't overdose again. And I know there's a lot of frustration from law enforcement, some of those that are administering, getting back to the same, and Chief Acevedo is ready to go. So I think that's one piece. We can't backslide. We need those particular resources. But then the general comment, the racial disparities, many prosecutors' offices are doing that very hard and heavy work to go case by case. But in opioids, I'd love to hear from the chief.
I think the difference is that opiates and the issue with it is not just in barrios and in poor communities and communities of color. One of my dearest friends' son, college graduate. I mean, it's impacting middle class, upper class. So I think that's going to change mindsets, and I think it's going to be a lot different than the crack epidemic. So, and it is in Houston. I think it's going on all over the country. But I want to first of all thank you again, Cyrus Vance, for the $2 million you gave me in Austin a couple years ago for the sexual assault backlot. I really appreciate that. And it just shows how much you do care, not just about your own local politics, but the criminal justice system. But Mr. Freeman, you said something that you have to be commended for. I get really frustrated on officer-involved shootings that we know that, prosecutors use prosecutorial discretion every day on all kinds of things. But then we have an officer-involved shooting. We have too many prosecutors that care more about the public perception, and so they will take every single officer-involved shooting to grand jury, right? And so then the media will have a narrative that says, well, in the last 5 years, 300 police officer shootings went to the grand jury, and 2 were indicted. Well, out of those 300, maybe 275 should have gone through through a process. And it cheats the public from getting a resolution. People are smart. Those that aren't going to trust us aren't going to trust us no matter what the process is. We need more prosecutors to have I think, the political courage to say, it's on video, here it is, we've reviewed it, we're not going, it's disrespectful to the grand jury process, and here you go. Here's all the evidence, because people are smart. Regardless of how they feel about the police, they have the intellectual capacity to make those decisions. Lastly, when you do it in a timely manner and you do release the information, it doesn't give time for people that want to create division between the communities that need us most by the false narratives that go out there that when you let them take hold a year later, when you come out and finally release the evidence, it's too late. You're never going to change minds. So I just want to thank you, and I just hope that as you on prosecutors talk about these issues, courage is not just about attending everything and having a process. So thanks for that.
Oh, Peter's after us.
I want to just talk about the other side of that. We have to operate by grand jury in our state. So if you charge someone with a felony, that is how you have to go. And we use the grand jury as an investigative body, not just a body to present evidence and then ask them to indict. So here's, in Manhattan, the history has been that we put these cases involving police-involved fatalities into the grand jury because if the grand jury voted a no true bill, which means that they voted that there was not sufficient evidence to charge, the public would know that it was not just the DA, him or herself, that made the decision, but that it was a public body who independently looked at it and made the decision. Now, I understand both sides of this, and I respect both sides of this. But it's interesting that in our state, it was designed to protect the integrity of the decision, and also, if we took some cases to the grand jury where there was a police-involved fatality where we felt the evidence was going to be sufficient to get an indictment, and we didn't put the ones in where we thought the evidence was clearly insufficient, and therefore, if we decided not to put it in the grand jury, then the police officers in the cases where we went into the grand jury would know that we felt there was a charge that should be brought against them, and that would affect the reaction of the testimony. It would dramatically affect the tenor of the relationships between our office and counsel for the police department. But if I was a police officer, I know, I completely understand how you feel. But in traditions, some other practices, I think, were done for the right motive.
We're about out of time, so I just want to thank our panelists and all of you for listening and having this really thoughtful discussion. Thanks very much.